Welcome to Section 1 of the Legal Implications Learning Module, the current legal status of cannabis within the United States. The legality of cannabis worldwide has been largely determined by the International Opium Convention of 1925. This convention banned the exportation of Indian hemp to countries that prohibited its use. It also required importing countries to issue certificates approving the importation and stating that the shipment was required, quote, exclusively for medical or scientific purposes, unquote. Required parties were also required to, quote, exercise an effective control of such a nature as to prevent the illicit international traffic in Indian hemp and especially in the resin, unquote. Cannabis laws are widely variable between different countries. As of 2017, the countries with the least restrictive cannabis laws included Austria, Bangladesh, Cambodia, Canada, Chile, Colombia, Costa Rica, the Czech Republic, Germany, India, Jamaica, Mexico, the Netherlands, Portugal, South Africa, Spain, Uruguay, and some United States jurisdictions. The countries with the strictest cannabis laws include China, France, Indonesia, Japan, Malaysia, Nigeria, Norway, the Philippines, Poland, Saudi Arabia, Singapore, South Korea, Thailand, Turkey, the Ukraine, the United Arab Emirates, and Vietnam. In the United States, cannabis remains a federal Schedule I controlled substance, which means, according to the federal government, cannabis has a high potential for abuse, no currently accepted medical treatment use in the United States, and a lack of accepted safety for use under medical supervision. It is still a federal crime to possess, buy, or sell cannabis. This also applies to individuals or entities providing services to cannabis businesses. For example, landlords or leasing agents who lease land or buildings to cannabis companies, providing janitorial or landscaping services, and even providing banking may fall under illegal activity when associated with a cannabis business. Decriminalization is the removal or reduction of criminal penalties in relation to certain acts. Oregon was the first state to decriminalize marijuana in 1973. The state imposed just a $100 fine for possession of up to 1 ounce of cannabis. As of the fourth quarter of 2019, 29 states have decriminalized cannabis in some form. It is important to understand that under decriminalization laws, the possession, sale, or transfer of cannabis is still illegal and remains regulated under criminal law. Typically, decriminalization means no arrest, prison time, or criminal record for the first-time possession of cannabis for personal consumption. In most decriminalized states, these offenses are treated like a minor traffic violation. However, regulated penalties or civil fines may still apply, including mandatory drug education or drug treatment for the offender. The downside of decriminalization is that it does nothing to address the illegal, unregulated market and the fact that products of unknown potency and quality are being sold to constituents through the illicit market. It also does nothing to address the issue of biased application of laws to minority groups, which is a large social justice concern in the cannabis legality space. Contrary to decriminalization, legalization provides a legally regulated pathway for the production, transfer, and consumption of cannabis. Legalization will be similar to the way that alcohol and tobacco are legalized, regulated, and sold in the United States. The benefits of legalization include tax revenue to local and federal governments, patients having access to safer, regulated products, and producers and retailers with legal access to the marketplace. Because cannabis is a Schedule I controlled substance in the United States, practitioners cannot legally prescribe it to patients. Medical cannabis programs in most states are regulated through a Compassionate Use Act. Compassionate use is a term used in the United States for a method providing experimental therapies to patients prior to FDA approval for use in humans. These compassionate care or compassionate use acts typically state that a practitioner can recommend cannabis to patients or certify that they have a medical condition which may benefit from medical cannabis use. The legality of practitioner certifications or recommendations of cannabis to their patients was upheld by the Ninth Circuit Court of Appeals in 2002. It was upheld that the government should be prevented from revoking the DEA registration of any physician based on their recommendation for patient use of medical marijuana. The ruling also cited the patient's First Amendment right to hear accurate information from their doctors and the state's rights to make their own laws without being subverted by federal commandeering. This ruling was key in providing practitioners with the confidence that they can recommend or certify patients for medical cannabis use without putting their DEA license at risk. In 2013, the Cole Memorandum was issued by the United States Department of Justice and sent to all United States attorneys. It stated that the Justice Department would not enforce federal marijuana laws in states that legalized marijuana in some form and implemented strong and effective regulatory and enforcement systems to control the cultivation, distribution, sale, and possession of marijuana, except where a lack of federal enforcement would undermine federal priorities. It also included an advisement against action against physicians recommending cannabis in states with legal medical use programs. This memorandum was rescinded in 2018 by then Attorney General Jeff Sessions. However, this was largely a symbolic gesture, as the power to prosecute remained in the hands of the United States attorneys. The Rohrabacher-Farr Amendment, also known as the Rohrabacher-Blumenauer Amendment, states that none of the funds made available in this act to the Department of Justice may be used to prevent states from implementing their own state laws that authorize the use, distribution, possession, or cultivation of medical marijuana. The amendment was first introduced in 2001 and passed the House in 2014 after 6 previously failed attempts. The Rohrabacher-Farr Amendment represents the first time either chamber of Congress passed a vote to protect medical cannabis patients, and it is viewed as a historic victory for cannabis reform advocates at the federal level. Similar to decriminalization, the amendment does not change the legal status of cannabis and must be renewed each fiscal year in order to remain in effect. The Rohrabacher-Farr Amendment is currently effective through September of 2020. After the Rohrabacher-Farr Amendment was passed, throughout 2015, the Department of Justice continued to prosecute medical cannabis providers who were following state law. The Department of Justice indicated they were interpreting the amendment as pertaining only to state officials, not to private individuals or entities. State officials, however, were not being prosecuted to begin with, so the Department of Justice essentially was saying the amendment had no effect. Interestingly, the Department of Justice itself advised members of Congress against the passage of the amendment due to the fact that they felt the application could apply too broadly, which is in direct contraindication to their argument for interpreting it incorrectly. This brought about a significant amount of uproar from the authors of the amendment on behalf of their constituents. In October of 2015, a court ruling by U.S. District Judge Charles Breyer affirmed the meaning of the Rohrabacher-Farr Amendment as originally intended. In his ruling, Judge Breyer stated that the Department of Justice interpretation, quote, defies language and logic, tortures the plain meaning of the statute, and is counterintuitive and opportunistic, unquote. Judge Breyer's ruling was upheld in August of 2016 when the Ninth Circuit Court of Appeals ruled unanimously in favor of 10 medical cannabis providers in California and Washington, rejecting the Department of Justice's interpretation of the amendment.